Hello, my name is Jannice Cebreros. I'm an undergraduate student at Central Washington University, Linwood, and today we'll be presenting my policy analysis on solitary confinement, civilly detained individuals, and Bureau of Immigration and Customs Enforcement. And I would like to share a little bit about myself. My name is Jannice Cebreros, and I am a senior at Central Washington University, Linwood. I am majoring in Law and Justice and minoring in Ethics. I was also an intern with the Washington State Legislative Internship Program this session and worked with the 2 Washington State House representatives. After graduation, I plan on going to law school to become an immigration attorney and be both a voice and resource for immigrant communities. I also aspire to become a Washington State legislator, and I believe that representation and diversity is very important in government. In my free time, I love to spend time with my family and my dog, read, and go hiking. First off, I would like to thank the Source Committee, CWU Undergraduate Research, my mentor Christine Henderson, and CWU librarians, especially Christine Birdie, who was so incredibly helpful throughout the process of developing my policy analysis and presentation. And a final thank you to all of you listening to my presentation today. I am completing a policy analysis which differs from social science research in multiple ways. I begin by explaining the difference. The difference between social science research and policy analysis is that policy analysis involves a high level of critical thinking and deciding which policy alternative or choice is best. Social science research, on the other hand, is the gathering of information for educational and awareness purposes without including specific policy changes. Policy analysis is important to create equity in Washington State because it allows the researcher and the audience to delve deeper into social justice issues that exist in society and work together to develop solutions to such issues. Policy analysis allows people to view social issues through a different lens and initiate and implement the changes necessary to promote equity and inclusion in their communities. I begin by defining some important terminology for my policy analysis. ICE is an acronym for U.S. Immigration and Customs Enforcement. ICE's focus is to strengthen border security and prevent the illegal movement of people, goods, and funds into, within, and out of the United States. Solitary confinement or segregation is confinement in an individual cell from the general population for administrative, disciplinary, or protective reasons. A private detention facility is a detention facility that is operated by a private, non-governmental, for-profit entity and operating pursuant to a contract or agreement with a federal, state, or local government entity. The PBNDS is an acronym for Performance-Based National Detention Standards. The PBNDS is policy for detention centers directly operated by Immigration and Customs Enforcement. And the NDS is an acronym for National Detention Standards. The NDS is policy for detention centers that are not directly operated by Immigration and Customs Enforcement, but still detain non-U.S. citizens. The policy I've analyzed is the Placement and Disciplinary Segregation Policy in the 2011 Performance-Based National Detention Standards, which declares the maximum sanction is 30 days in disciplinary segregation per incident, except in extraordinary circumstances. The same placement and disciplinary segregation policy applies to the 2019 National Detention Standards for non-dedicated facilities. The topic of my policy analysis is the current use of solitary confinement in ICE detention centers. The purpose is to research and study the use and effects of solitary confinement as a form of discipline in ICE detention centers and current legislation. And the goal is to inform the public of this social justice issue and ultimately impact future legislation to make timely and critical policy changes. Now, to summarize my problem statement, ICE uses solitary confinement or segregation as a form of discipline and are given significant discretion in deciding the reason and length for this disciplinary action, and often use it as a form of coercion or a fear tactic. ICE personnel also often place individuals with underlying mental illnesses in segregation. According to Tobino, 13.5% of deaths in ICE custody are suicides, often associated with the inhumane treatment and lack of proper mental health care offered in the facilities. ICE detention centers are mainly privately owned and operated by Geo Group and Core Civic, who profit off the detainment of people in ICE detention centers. Now I will go into the evidence and support for my policy analysis. O'Sullivan with the Seattle Times discussed a report that the ICE detention facility in Tacoma, Washington violates ICE solitary confinement policy by placing detainees with mental illnesses in solitary confinement. Kelly with the Office of the Inspector General stated that during an inspection of 4 ICE detention facilities in 2019, 3 facilities had segregation practices that violated detainee rights. And DeLuan stated that in fiscal year 2017, Geo Group and CoreCivic earned a combined revenue that exceeded $4 billion. The high combined revenue of these entities that operate these private for-profit detention centers points to a possible profit motive. Now I would like to discuss the qualitative evidence that I gathered from my policy analysis. In a 2018 United States District Court case, Flores v. United States Immigration and Customs Enforcement, Flores plaintiff claimed that ICE officers at the ICE Detention Center in Tacoma, Washington, had assaulted him and placed him in solitary confinement for participating in a hunger strike as a form of protest for unjust treatment and living conditions within the facility. In another incident, according to a video by The Intercept, in 2018, a Mexican immigrant in ICE custody named Efrain Romero de la Rosa was placed in solitary confinement even though he had been clinically diagnosed with schizophrenia. He later died by suicide. And Manuel Abrego was detained in the Northwest Detention Center and was placed in solitary confinement for 8 months, 23 hours a day. The cases I have mentioned today are significant in bringing awareness to this issue, but they do not represent all the allegations against ICE. There are many more stories that I will not be able to share today, but I hope that the ones that I have shared will bring awareness to this social justice issue and the need for policy change. And according to this figure by the University of Washington Center for Human Rights that includes data from 2016 to 2018, the Northwest Detention Center in Tacoma, Washington, places individuals in solitary confinement longer than any other facility, going up to 70 days in solitary confinement for civilly detained persons. One related policy is the 8th Amendment in the United States Constitution, which declares, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." It is cruel and unusual punishment to place a civilly detained individual in solitary confinement, especially for exercising their rights through peaceful protests like hunger strikes. The amount of discretion that ICE personnel are given in terms of who to place in solitary confinement and for what reason is an issue that must be addressed. One solution that will make a big difference in the safety and well-being of all people in Washington state is House Bill 1090, which would prohibit the use of private for-profit detention centers in Washington state. House Bill 1090 has passed the House and the Senate with bipartisan support and has been signed by the governor. House Bill 1090 will go into effect in 2025. When analyzing policy and developing solutions, we must ask ourselves questions in relation to the possibility of implementing the alternatives. In terms of political viability, we must ask ourselves, will influential companies and stakeholders that have contracts with Geo Group and CoreCivic accept the alternative? In terms of social and cultural feasibility, can the alternative be implemented in a community with local traditions, policies, institutions, and overall social and cultural values? In terms of equity, is the alternative equitable and inclusive? And in terms of cost effectiveness, can each alternative be rationally implemented? Is it cost effective? I would like to offer some alternative policy responses. One alternative is for the placement and disciplinary segregation policy in both the 2011 PB/NDS and the 2019 NDS to be analyzed and revised to improve clarification and decrease personnel discretion. Another alternative is to prohibit the use of private for-profit detention centers in Washington state, which has already been initiated through the passing of House Bill 1090. The best alternative is to prohibit the use of private for-profit detention centers in Washington state, which has already been initiated through the passing of House Bill 1090. As for now, until House Bill 1090 goes into effect in 2025, it is critical that the placement and disciplinary segregation policy in the ICE 2011 PB/NDS and the 2019 NDS be reviewed immediately, and proper measures taken to ensure the health and well-being of civilly detained individuals. The ICE detention center in Washington state may be closing, but there are still immigrants detained in city and county jails, which is why it is so important that we analyze and revise the placement and disciplinary segregation policy in the 2019 National Detention Standards for non-dedicated facilities. I would also like to remind us all that private detention centers may be banned in Washington state, but they're not banned federally. and human rights and the well-being of all people should be of paramount importance. I would like to end with some final thoughts. Numerous allegations and evidence of detainee mistreatment and abuse requires urgent action. And ICE detention is meant to be civil, not criminal, so there is no need for the use of solitary confinement as a disciplinary action. And 30 days in solitary confinement is too much time, especially as a form of discipline in a civil detainment center. Thank you for taking the time to watch my presentation on my policy analysis. I have provided my contact information, and please feel free to reach out to me with any questions or comments you may have. I'm also happy to produce my policy analysis upon request. Thank you and have a great day.